Good evening, everyone. I hope that you have had a chance to look at my previous lecture, which was the General Exceptions of Private Defense Part 1. I tried to cover all the basics of what is private defense in that particular lecture, where I wanted to discuss with you all what is the importance of proportionality in private defense, what is the importance of the lack of presence of any kind of public authority who you can have recourse to, and that these are the certain basic scenarios in which private defense can be exercised by an individual. Now we are going into a further discussion with regards to private defense, and we now directly start with section 38. Now this is section 38 of BNS and section 100 of IPC. There are some small changes that we will discuss as we go along this particular section, but by and large the section remains the same, right? So we do a quick reading of this section and then we have a discussion on the section. As this section starts, you see that it states that the right of private defense of the body extends under the restrictions specified in section 37. That is the restrictions that we have already studied, to the voluntary causing of death of any other harm to the assailant, if the offense which occasions the exercise of the right be of any of the descriptions hereinafter enumerated, namely such an assault as may reasonably cause the apprehension that death will otherwise be the consequence of such assault, such an assault as may reasonably cause the apprehension that grievous hurt will otherwise be the consequence of such assault, an assault with the intention of committing rape, an assault with the intention of gratifying unnatural lust, an assault with the intention of kidnapping or abducting, and goes on to talk about an assault with the intention of wrongfully confining a person under circumstances which may reasonably cause him to apprehend that he will be unable to have recourse to the public authorities for his release, or an act of throwing or administering acid, or an attempt to throw or administer acid which may reasonably cause the apprehension that grievous hurt will otherwise be the consequence of such act. So we can clearly see that this particular section gives you a larger right in the context that you can even go ahead and cause the death of the individual who has tried to commit some form of harm on you. But now, what are the keywords that you must remember when you are dealing with this particular section is that an assault as may reasonably cause the death of an individual, meaning you are under fear of death, that death might be the outcome of the assault that the front person is doing to you, and therefore you too have a right to do an action which could amount to that assailant's death, right? So we see that this offense of assault is also mentioned in the section. What very often happens is that we are so focused on these parts like rape, lust, abduction, etc. We forget that there is another aspect which has been mentioned in the section also, which is of assault. So we see in that the subsection A, it should be an assault which leads to an apprehension. What is an apprehension? A reasonable apprehension is something where a normal person fears that this assault is something which could lead to death in the first section. Then we come to an assault again, which causes grievous hurt. And we know that these terms like grievous hurt also are defined under our legislation, and therefore when you're reading them it must remain in tandem. So an assault to cause grievous hurt, an assault which could lead to the commission of rape, an assault which could be gratifying unnatural lust, or an assault leading to kidnapping, abduction, or wrongfully confining. But here there is another statement which is important, that they are highlighting something, which is that the confinement should be such, again, that there is no recourse to public authority. There is the act of throwing, Here the word assault is not present. We know that this was introduced under the Criminal Amendment Act of 2013, right? And where it was said that throwing of acid or the attempt to throw it would also be something where you could exercise your right to private defense. Now, just for an ease and for your reference, I've provided relevant sections and what are the main offenses that we can see, which if are put against you, you have a chance to use the right to private defense. I have also introduced to you the definition of assault. Very often, when reading this section, we forget to clearly understand what is an assault. It is a gesture. This gesture can also be accompanied by words, or it can be a preparation where, in such a case, that you feel threatened that some kind of force is going to be used against you. So, that is an assault, and we see that this term is repeatedly used in the section and is coupled with another offense. Or in the first half, we have seen that it also says that an assault which gives you a reasonable apprehension of death. Now, while dealing with this section, there are some things we must remember. The first thing being that section 99 of IPC, or whether it is section 37 of BNS, provide to us the limitations on private defense. What are they? That if you have recourse to public authorities, you cannot use private defense. That private defense should be proportionate. And also that if there is an act being done by a public servant or under his direction and you are aware of the same, then you don't have the right to use your right of private defense. So those restrictions continue to be applicable even on this section. And you, as an individual, when using these rights, must be free from fault, meaning you are, as the term suggests, defending yourself. You must not be in any way committing a wrongdoing. You must be at the receiving end of a wrongdoing. We then move on to this fact that you must really feel that there is some kind of harm that is happening to you. Now, even if you look at these particular offenses that are here, you see that these are things where bodily you are at a you find them seriously against your body, whether it is the offense of rape, unnatural lust, kidnapping, abduction, and so on. Right? So these are serious offenses. You are going to feel serious peril towards your body. And there must be no option of retreat available to you in some sense or the other, meaning it is so eminent to you, the danger is so present that you have to have some kind of defense in yourself at that moment, right? You don't have any recourse to anything, right? Because you're taking the life of an individual, it is important that that is a necessity, meaning you don't have any other option but to take the life of an individual, right? For example, if somebody is right close to you and is using a knife against you or is almost going to stab you, and then in retaliation you use whatever is available to you on that person's body and they pass away, so this is a necessity to you, right? You don't have an option, but because the peril to your body is such that you must do that, right? That also, now what is important is in the same example which I just gave you, there is no harm that has actually been done to you right now, but you are under an apprehension, right? So it's not necessary that an actual injury must come to you. You must apprehend reasonably that there is going to be some harm to you, and therefore there is the word assault involved. The gesture must be there, the preparation should be there in such a extent that you feel that you are under real threat to your body, right? Now, what is reasonable apprehension? What one individual will feel is reasonably apprehendable as a threat to your body is a question of fact. It will be determined by whatever facts are put across in that particular case by the court, that whether it really did come under the ambit of this section, and that it could also amount to the taking away of the life of the individual. So that's a question of fact. It will differ from case to case. Now, coming to this part of unnatural lust. Now, we know that under IPC section 377 existed, and while part of it was decriminalized, a half of it where non-consensual unnatural acts were there, that was retained. Now the problem in BNS is this has not been addressed. So while the section is interestingly saying that an act of unnatural lust or an offense, assault of unnatural lust is a private defense, which hints that this is an offense, but it has not been listed anywhere. And therefore, we don't know how to deal with it. And we see that even a PIL has already been filed on this matter. I have provided the citation if you want to read it in detail. But even the court has said that at that time that they are not in a position to create law, right? It is the job of the parliament to create the law. So while you are allowed to make your petition in front of the court, the court cannot create a law where there is no law, and that would be then referred to the parliament. So this debate in on is on, and this does create some sort of a gray area as to where and how unnatural lust is dealt with under BNS, and therefore under this section also. Right now, coming to this part, that is abduction. If you have an understanding, and we may go in depth into this when we deal with it in our classes, when we deal with abduction is something which usually requires, when you deal within the legislation, an additional form of intent, like an abduction to commit murder, an abduction to commit some other act, right? But the section only mentions abduction. Now what do you do? So, first problem is this. Second problem is this, that there is an interesting case which would help us while through discussion to understand also this point, is that once when a husband was trying to take his wife back home from her father's home, and she didn't want to go, and her brother comes and tries to stop the husband from taking her. What happens, and how basically the brother harms the husband dies, and the brother says that I have a right of private defense because I was trying to protect my sister who was being abducted by my husband. So now we will look into this case of Vishwanath versus State of Uttar Pradesh. Just give me a moment. I will share the screen. Right. So here we see the case of Vishwanath versus State of Uttar Pradesh. As I told you the facts of the case, there were a husband and wife who were not very happy together. The wife goes to the father's place. The husband comes to take her. The brother stops the husband, and because the husband is forcing the wife to leave, the wife holds on to the door of the house, and then the brother, in order to stop the husband, just gives one dagger, just stabs him once. Unfortunately, that stabbing happens at the heart of the husband. The husband collapses and dies. Now the question comes in is whether this is the right to private defense. This brother says that, he was abducting my sister. But can a husband abduct the wife, was the question that came into picture. This is the set of the facts you can look into after some point of time. As I said, that there is a highlighting of this particular defense which is available to us in abduction, right? And we see that further the term abduction is defined, and the conversation of the term abduction is said to be that while usually we require additional intentions along with abduction, but in this part what is very interesting is the court also elaborates on the fact that the word abduction is also in this particular section, which is section 38 of BNS and section 100 of IPC. The word assault is involved, right? So if you read this para 7, it says that the definition of abduction is in two parts: abduction where a person is compelled by force, and abduction by deceitful means. Section 100 only deals with force, so it deals only with forceful abduction, which was happening in this case. the wife was being forcefully taken by the husband. It is in our opinion that right to expect from a person who is being abducted by force to pause and consider whether the abductor has further intention as provided in one of the sections of the penal causing death of the person is not required. The framers of the code knew that abduction by itself was not an offense unless there was some further intention coupled with it. And section 100, the word has been used without any further qualification to the effect that the abducting must be the kind mentioned in section 364. We are therefore of opinion that the view of the prosecution is not correct. And here the court goes on to then elaborate on the fact that the word assault is also involved with abduction. And therefore, for this purpose, there is a right to private defense which is available to the brother. And lastly, it ends with the line that these things cannot be weighed in too fine a set of scales of in scales or in golden scales. This is something which we have discussed in the previous lecture also. It may look prima facie that the husband has died just to take away his wife, but in this situation, we must also remember there was only one blow given by the brother. Unfortunately, it was in a location which caused his passing. But in this context, the court felt that it was valid. Abduction can be done by a husband. Abduction is involved here independently in simpliciter form, along with the concept of assault attached to it. And therefore, the brother was rightful in defending his sister. And even if a death was caused, that he was right in this part. Like if you can see here, he was acquitted and the defense was granted to him. Yes. So we have now understood Vishwanath versus state of Uttar Pradesh. Husband tries to take away wife. Brother uses one blow, and with that one blow, this husband passes away. Court says brother does have the right to defend the wife, and it is a case of which is covered under this section. Now, another important facet which I felt should be dealt with at this point is that the court, if you've seen my previous lecture, I have pointed out that the court does have the option where it might independently also provide the plea of private defense to an individual, right? Now, these are instances where an accused has injuries on his body, but the prosecution has not looked into the fact that he has injuries. The prosecution has not even thought that it might be that this accused has act under some form of private defense. So, for example, let us say there are two people, A and B, and while B has committed harm to A, and A also in this scenario has lot of harm to himself, as I correctly said, and B also has harm to him. Now let us say that the court prosecutes A for the harm A caused to B. But originally, it was A who was the person who received harm, and therefore he too has injuries on his body, which has not been recognized by the prosecution. So the court says that this can affect the case. If it is found that the accused has injuries on his body and the prosecution has not recognized it, then in that scenario, the court feels that it is the suppression of the origin of occurrences. You are not telling what is the original case, you are telling your story, you are not telling the real story, and which may involve some things on behalf of the accused. Secondly, any witness who did not acknowledge or denies the presence of these injuries, he is also or she is also a weak witness, because why is that person not acknowledging or speaking about the injuries of the accused? So makes the evidence slightly questionable or unreliable. But at the same time, the court in these particular in Lakshmi Singh's case also said that while number of injuries on the accused may affect the case, but at the same time, some cases may be very clear where it may be that accused has injuries, but he was the perpetrator. he was the offender and that's why he's been punished. In those type of cases, injuries of accused will not be affecting the case if it has not been explained by the prosecution. I hope you all have understood this. I'll still repeat myself once more. Accused, if he has injuries on his body, the prosecution must look into it why accused has injuries. If they don't look into it, it can affect the case. It can affect the originality or how the case happened. The question might come up that there are things which are not true in the particular case. But the court has then finally also said that it number of injuries can sometimes be there in such a situation where it is still obvious that the accused was the perpetrator of the crime. In those scenarios, it will not affect the case. So just some additional information that you can know when you are dealing with defense or the concept of private defense. Now we go on to our next section, which is when such right extends to the causing of harm other than death. So we dealt with in this previous section situations where private defense extends to the causing of death. And in this scenario, we deal with those situations where you cannot cause death, right? And the section is very simple. It states that if the offense be not of any of the descriptions specified in the previous section, the right of private defense of body does not extend to the voluntary causing of death to the assailant, but does extend under the restrictions specified in section 37 to the voluntary causing to the assailant of any harm other than death. So simply this section is stating that previous section you are allowed to cause death only for those situations which were provided, as we discussed: rape, unnatural lust, abduction, wrongful confinement, so on and so forth. But apart from those situations, you cannot cause death. You can cause any harm, but you cannot cause death, right? And again, just like the previous section was subject to the limitations which are there in private defense under section 37, those same restrictions to come back in section 39. You are expected to be the defender of an act, meaning that you can never be the aggressor. You are the recipient of some kind of aggression. You must be acting in proportion. You must not have recourse to public authorities, and this should not be any act which is done by a public servant. So those limitations which were applicable on section 38 continue in 39. You still have the right of private defense for any other offense than those mentioned in 38, any other situation than those mentioned in section 38. But the only difference is now you cannot cause death. You can cause any other harm but death, right? Moving on to section 40, commencement and continuance of right of private defense of body. Now, again, this is very, very relevant as to when your right of private defense starts and when that right of private defense ends. The right of private defense of the body commences as soon as a reasonable apprehension of danger to the body arises from an attempt or threat. This is relevant. From an attempt or threat, there should be real apprehension of danger from an attempt or threat to commit the offense, though the offense may not have been committed, and it continues as long as such apprehension of danger to the body continues. What is very interesting in the section is that it repeats one facet, which is it is not necessary that something must be done to you. What is necessary is that you feel an apprehension through some kind of threat or an attempt that something might be done to you. So may not have been committed. It's not necessary that the offense is committed. What is necessary is that you apprehend danger through an attempt or threat that it can be committed on you. And there is nothing better than taking an example wherein this interesting incident happens. A and B have some sort of dispute. Because of that dispute, let us say one of them harms the other. Now, that harm is done in the evening, the panchayat is sitting to resolve the matter. At that time, this injured person goes and hits this person who had harmed him, saying that this is private defense. It is not. Why? Because that apprehension of danger was there only at the time of injury. Here, you are now getting this matter resolved and you are in front of the authority who you have taken recourse to. So, at this time, the danger was not there, the apprehension was there, not there, no attempt was there at you at that point, no threat was there to you. That fear and that apprehension is over when the injury was committed. So at this time, the right of private defense is not available to A. It was available only when the harm was being done to that person, right? So again, apprehension of danger must be there through some kind of attempt or threat which has been done to you, and it is not necessary that there may have been a any kind of act committed. What is necessary, that there is a threat or an attempt which creates an apprehension of danger. Now we go on to our next case. Again, an interesting case, and which tells us that how apprehension of danger plays such an important role in private defense. Now, what is the case of this individual? The case is there are two set of groups of people. There is one set of group, that is A. They come with a tractor and they are trying to plow this field. There is another bigger group of people, B, and these people are also saying that this field belongs to them and the crop on it which is growing is theirs. Now, group A has come with a tractor and is trying to remove or, uh, remove the crop that is there on this field, stating that it is their field. The larger group which has come on foot, B group, is stopping them and they start stopping the tractor. Now, please bear in mind, group A, which is on the tractor, has weapons with them. They have pistols with them, they have guns with them, they also have some sharp weapons with them. And this large group is trying to stop them. Now, what happens is when the tractor is stopped, they start firing. Now, in that moment, a few people die. Now, but what is the interesting part is after this, one person from B group says, please stop using the guns. Let's not kill anybody. And at that moment, group A, the tractor group, uses the gun and kills this man. His name is Amin Lal, who was saying to stop this action from the large group, group B. So what happens is that Mr. Amin Lal, once he passes away, all the people, the villagers, the group B, the large group, they all start running away. Now they run away, they are far away. The interesting part is the people from the tractor who had the guns, two of them, they continue to shoot and they still kill two people. Right. And now you can see in the parts that I have highlighted is that firstly, one thing, that whose land was it, that came into debate. That is for the, whether the villagers were in hold of the land or whether this person was in the interest of the land. Another thing is, now, as I told you, the set of facts that Amin Lal tried to stop the harm that was happening and then he was killed after which. And then here we see that in some part of this para, you will see that they are using firearms, they are harming these individuals, and these people are located far, far away. So, for example, these tractor individuals were using the guns, and those people were 50 feet away, 80 feet away. some were in their own lands sitting in a machan. So the court said if an individual is sitting in their own field on a machan, how are they a threat to you? How is there any apprehension of danger? The second person also which was killed after Amin Lal died, he's also very far away. So when these individuals are so far away, what was your apprehension of death? What was your fear that you were going through, that you have used private defense? And then the court said you are not entitled to the right of private defense because you sincerely didn't have any apprehension. The apprehension when it was there, that when they stopped the tractor, they were a large group of people, you were under some kind of fear, and therefore you stopped this particular conflict by using your guns. Those people, we understand that there was some logic. But when Amin Lal has died and he had tried to stop and all the villagers were running away from group B, then why did you continue with this type of with this type of harm? And the court said you are not justified. This right to private defense did not continue. In fact, it had stopped as soon as these villagers in the group B started to run away. And therefore, your killing of these two individuals, out of which one was in his own field on a machan, and the second person who was very, very far away from you, does not come under the ambit of private defense because it did not continue. It had ended as soon as they started running away. Your right of private defense had ended. So these two deaths will not be given the protection of the right of private defense. I hope I have made sense to you all. Moving further, we now come to the context of right of private defense if it is available to you against property. Right now, as we have discussed in the previous lecture, it is available to you to both body and property. And as we have discussed in the first half of this lecture, the right of private defense of body can also go to the extent of death. Same way, it in the context of right of private defense of property also, it can extend to the causing of death. So let's do again a quick reading and then we go back to a discussion. So the right of private defense of property extends under the restrictions specified in section 37 to the voluntary causing of death or of any other harm to the wrongdoer if the offense, the committing of which or the attempt of which occasions the exercise of the right to be an offense under any of the descriptions hereinafter enumerated, namely robbery, house breaking after sunset and before sunrise, mischief by fire or any explosive substance committed on any building, tent, or vessel, which building, tent, or human vessel is used as a human dwelling or as a place of custody for property. Right? Then we go further and see that theft, mischief, or house trespass under such circumstances which may cause reasonably an apprehension of death or grievous hurt will be the consequence of such right of private defense if not exercised. So we see quite simply that again a set of situations have been given where the right to private defense of property even extends to the causing of death. What is interesting, if you just see the section, you realize that these are all very serious offenses. Robbery, we know that if we read the definition, it involves this threat of instant death or instant grievous hurt. Housebreaking at night, that is before sunrise and after sunset, is also a serious offense. It in itself also involves a serious threat. Mischief by fire, whether it is in a place which is a human dwelling or has a property, we again see that while this is related to property, if you see there is an overtone where it protects body also, because robbery involves a threat to person, instant death, instant grievous hurt. Those terms are there in robbery. Even housebreaking at night, which is after sunset, is a serious offense, because in itself also it includes another offense, right? Mischief also, where a human dwelling is there or property is there, you see the context where again life is becoming important along with property. Even in in this next situation, you see theft, mischief, or house trespass under circumstances which cause apprehension of death. So even very interestingly, in this section, while it is about property, you see that there is a lot of conversation of death of an individual or risk of death of an individual and grievous hurt, right? So just for your comfort, again listing the sections which are involved, the situations which are involved: robbery, housebreaking, mischief of human dwelling, and theft, mischief, or house trespass. But this is in a situation where death or grievous hurt could be a consequence. So I just wanted to point out again that these, while there are property offenses, you do see in some of them an overtone where they are trying to protect human life again, and therefore maybe we are entitled to take away life in this type of a section. You're entitled to take away life if these situations are fulfilled. Again, as we have discussed before, the restrictions on private defense which existed, they will again come into picture, are applicable here also. So proportionality, that you should not be the wrongdoer of the offense, that there should not be recourse to public authorities available to you, and that this should not be acts of public servant, etc., who are doing actions in the color of their work, or somebody is working under their direction. If these limitations are fulfilled, only then your right of private defense in these certain situations can extend to the causing of death of an individual, right? Now, going further, again, this is a situation wherein they have told us what offenses, if committed against property, could give you a right of private defense where you can even cause death. But there is now the scenario of what are the situations wherein you cannot cause death. And the section is enumerates that the committing of the offense, the committing of which, or the attempting to commit, which occasions the exercise of the right of private defense, that right does not extend to the voluntary causing of death, the theft, mischief, or criminal trespass, not of any of the descriptions specified in section 41, but does extend, subject to the restrictions specified in section 37, to the voluntary causing to the wrongdoer of any harm other than death. So, similar to the section with regards to body, in this situation also, we know that now you have a right to protect yourself, you have a right to cause harm to protect yourself, but that harm cannot amount to death, right? And theft, mischief, criminal trespass, which are not under the description of the previous section, are coming into the ambit of this particular section. So you're still allowed to protect your property in these situations, but it is limited only to any harm other than death. Death can only be caused in the situations listed here, right? And again, I'm pointing out to you that here you see that the overtone is serious. The offenses are serious in the context of that there may be some form of life may be involved in those offenses, right? Coming again to the commencement and continuance of this right. And this is a discussion which is interesting. The right of private defense of property commences when a reasonable apprehension of danger to the property commences. We see the same line being used. Apprehension which any normal individual will feel of danger. As soon as that is there, you have your right of private defense. Now, against theft continues till the offender has effected his retreat. Now, this line is something we will get into in depth. Offender has affected his retreat with the property, or either the assistance of the public authorities is obtained or the property has been recovered. So, what does it simply mean? If somebody is trying to commit theft, till that offender has effected his retreat with the property, or either the assistance of the public authorities you have obtained or the property has been recovered. Until these situations are not there, you have a chance to use your right of private defense. Against robbery, it continues as long as the offender causes or attempts to cause any person death or hurt, wrongful restraint, or as long as the fear of instant death, instant hurt, instant personal restraint continues. So you again see that while it is an offense of property, but the harm to life becomes the defining factor in this situation as to when the right of private defense commences and till when it continues. So in robbery, you see, as long as you feel that the person can attempt to cause your death, hurt, or wrongful restraint, you have your right to private defense against property available to you. Against criminal trespass or mischief continues as long as the offender continues in the commission of criminal trespass or mischief. So as long as the person is committing or tries to do these offenses, you have your right, which points out a very important thing. It says to us that once this thing is done, your right is over. It means that when we studied the essence of private defense, why is it available to us? Because we don't have the time to go through the proper channels to the proper public authority. But once the act is done, the threat is over, it is expected that you go to the proper channel, you take relief from the proper channel that is available to you, and therefore your right of private defense is only there till that offense is there. If it is completed against you and the threat is over, then in that scenario, you are expected to go and take normal methods or steps of recourse of justice, right? To go to the right public authorities for those reasons, right? Against housebreaking after sunset and before sunrise continues as long as the house trespass, which has begun by such housebreaking, continues. So again, we see housebreaking is what when somebody enters your house and if there is an intention to commit some offense inside your house. So again, we see the legislation is saying that as long as that person is there and is trying to do that, you have that right. Which implies when they are no more there and when that act is done, you don't have the right. You have to go back to the normal, proper channel. So it's very important to understand to what extent is that right. Okay. Now we have understood this section, but there is this term, as I told you while we were discussing it, which is something we must discuss. When it comes to the offense of theft, it continues till the offender has affected his retreat. What do you mean by this term? Effected his retreat generally meaning means where the person has left with the property, right? So if the person has left, then you don't have the right to private defense against that particular individual. He is left with the property. But there has been debate on this particular topic. There has been question as to, let us say that there is a situation wherein A has tried to steal B's watch, and he steals the watch and he runs away. Now, next day, B sees A wearing his watch and kills him and takes the watch. The question comes in, B says, I am exercising my right of private defense. He has my watch. But if you read the section states that once he has effected his retreat, you are done with your right of private defense. And very often this discussion has come up that why, when you have the offense is over, why not go to the public authorities and then file a case and then follow your particular due course of action, right? Because as we know, the private defense is available to you only when there is imminent, immediate threat. In such situation, the offense has been committed, right? And when we, one might also use this discussion to talk about the fact that, ma'am, here there is also the word, the property has been recovered, so he's trying to recover property which he found with A, and therefore his private defense is there. But you must understand, when we interpret a section, a lot of it essence comes from what is read around it. Look at how these sections are framed. They are all talking about that as long as the offense is immediately being committed, only then you can exercise it. Once it is over, once that act is done, even if you have suffered harm, your right of private defense is over, and now you will have to go to the proper public authorities for justice, right? So from these other situations, what we understand is it is just an immediate right of recovery. So what they probably mean to say is that he has committed theft, but the property is left behind, right? He's stealing jewelry, but the jewelry you got it back, he has run away. In such situation, it means that you've recovered property, your right of private defense is over. You still want justice, you will go to the public authorities which are apt for this particular situation. So it's, this right is not something which is drawn out. It is a right limited to a certain limited time where you're feeling imminent danger of a threat of some kind of serious harm which can be done to your property or to you, and then you're exercising it. After that is over, you're supposed to go to the right authority. Now, to further discuss that particular point, I have provided to you this particular situation. This has been a question which has also come in the mains. While J was committing theft in K's house, he was surprised by L, a tenant of K. J took his heels, carrying with him the stolen jewelry. Right? So J is running with stolen jewelry. L raised a lathi to strike J, who forestalled the danger and shot L dead. J was arrested and put to trial for the murder of L. J argues that L raised a lathi to strike. There was a reasonable apprehension of grievous hurt, and death of L was caused in the exercise of his right of private defense. Now, read this question very carefully and understand that apprehension of danger and the quantum and proportionality of private defense plays a very important role. So if we see this question again, J is committing theft at K's house and he was surprised by L, who is a tenant. J took to his heels with the stolen property. L raises a lathi to strike him. J, who forestalled the danger and shot L dead. J was arrested and he has been put to trial for the murder of L. Now, in this particular situation, J is the perpetrator of the offense. L is the person who witnesses him. J starts running. L tries to stop him. And L, while trying to stop this individual, using his right of private defense, which is has J, what is done? J, who is the perpetrator of the offense, he shoots L dead. J was, as the section, as this particular incident states, that put to trial for the murder of L. Arguments, what would be the arguments that you would raise? Right? Now, the question comes in that can an aggressor be the recipient of the right to private defense? This again comes to the fact of the case that he feels that his danger was so much that he had to shoot L dead. We have to remember in this situation, that J is the perpetrator of the offense. L was exercising a right of private defense. That right of private defense was also that he used a lathi to stop, which one could say most probably is commensurate to the act that J was doing. He was using a lathi. Now, J, who is the perpetrator of the crime, who is doing a wrongdoing, and who L is trying to stop, shoots him dead. So the question comes to that, the fact that does, if he feels he's going to die with a lathi that he raised to strike, the and that could have caused his death, and therefore he used the shot that was fired at him. The question brings us back to the basic essences of private defense, that the right, where does the right of private defense start for even an accused, for even an offender, the person who was the aggressor. In this situation, Jake can argue if he wants that he felt that he could be in real harm of death or harm or danger, and therefore he felt that he was exercising his right of private defense. But at the same time, we know that L was using a right of private defense to property and was commensurately using a lathi to try and stop him, and he was killed in that part. And therefore, mostly that there could be a debate on whether the accused was entitled to the right of private defense. Furthermore, let us take another case. Let us take the case wherein there are two people, A and B. B comes to the house of A and tries to steal something. Now, A catches him stealing and goes after him. B runs with the property back to his house, shuts the door. A breaks into the door and tries to kill him and kills him. Let us say A has, who found B stealing at his house, runs after him, reaches his house, breaks his door, and kills B, saying that I have a right of private defense. Question is it available to you? Again, this is a question that has been asked in your papers. Does A have the right to follow B back to his house, break open his house, and kill B just because B stole his property? Answer is no. And referring to the case law that we have in front of us, you can see that the right of private defense does not allow a person to chase and kill his assailant who is running away from the scene. So we realize that an individual who ran away, who is again coming back to the word, affecting the retreat, and in every sense we can say he's affecting the retreat. How? Because he's gone back home, he has shut his door, his retreat is over, he has escaped, but you still follow him. Maybe you even pass a police station which you should have gone to. Rather, you go after him and you kill the individual. The right of private defense is not available to you. In this situation, he had effected his retreat, he has gone away. Now, where you should have gone was to the proper public authority. Because, again, repeating myself, this section clearly states that it commences when there is some kind of apprehension that you're facing. Even in context of theft, it is that where the theft is happening, you are having the right. But once the person has effected his retreat, they have gone away, or where you have received the assistance of public authority, or where you have recovered the property, he was not able to take the property, your right is over. After which you must let the public authorities come into picture and take care of the further acts of justice required. So, repeating myself, commencement and continuance of right of private defense to property is when you actually feel a apprehension of danger, a reasonable apprehension of danger. In matters of theft, as we just dealt, if someone has affected his retreat, the offender has affected his retreat, or if such person has taken assistance of public authority, the victim has taken assistance of public authority, or the property has been recovered, at this point your right is over. Before these situations, your right exists. In robbery, we see again that as long as there is threat to life or instant hurt, your right is there. Once that is over, or even the threat to wrongful restraint is there, till that time it exists, after which it does not exist. Criminal trespass or mischief, as long as that these offenses continue, you have the right. Once they are over, you do not have the right. Lastly, housebreaking takes place, then in that scenario also, house trespass, as long as it's happening in the night, you have your right which is available to you, after which it goes away. We had a discussion wherein sometimes maybe an aggressor can also have the right to private defense if the private defense used by the other person is of such an extent that it has now gone away from being a right of private defense, and it has exceeded to such an extent that even the aggressor has a right to protect themselves. That can be a question which can be dealt with in depth. And lastly, I also discussed with you in this part that there are situations where a person may be committing theft at your place, but once he has effected his retreat, it is not your job to follow and try to take justice. You must go to a court of law. Now, the next section talks about a situation wherein right of private defense exists, but if you use it, you may cause some harm to individuals who are innocent, who are involved in the situation. So the section states that there can be such situations, and you are still entitled to exercise your right of private defense. You can still go ahead and use your right of private defense. We'll quickly just give it a read. If in the exercise of the right of private defense against an assault which reasonably causes the apprehension of death, the defender be so situated that he cannot effectually exercise that right. He cannot effectually, meaning it won't be an effective act of right of private defense until and unless there is a risk of harm to an innocent person. His right of private defense extends to the running of that risk. So you are still entitled to that risk, you are still entitled to that right, even if there is a risk of harm to an innocent individual. The illustration to this particular section, I feel, is the most suitable illustration. It states that A is attacked by a mob who are trying to kill him, him. And so, in order to defend himself, to use his right of private defense, he will have to shoot at the mob, and that mob may include some innocent people like children. And the legislation allows him to run that risk. He's still allowed to use the gun, even if that firing of that gun could put children at risk. So, even if innocent people are put at risk, if your private defense requires you to use some kind of harm, and which cannot be effectually done until and unless some risk is there to innocent people, you can still go ahead and do it. That risk is allowed under this particular section. Right? Now, one last question that I have kept in, and then we can just do a short recap, is X enters the house of Y to commit theft. He is caught by Y, starts beating him mercilessly. X, apprehending death or grievous hurt at the hands of Y, pulls out a knife and stabs Y, who is injured seriously. Can X put up a plea of private defense? It is similar to the question that we discussed previously, and I have purposefully wanted to end on this point, is that, and it has been asked as I've highlighted previously, There are some hints to this question which are already present within it. For example, X enters the house of Y to commit theft. He is caught by Y, who starts beating him mercilessly. Mercilessly is a term which hints towards excessivism. X, apprehending death or grievous hurt at the hands of Y, pulls out a knife and stabs Y, who is injured seriously. So he is beating mercilessly. This person, the offender, feels he is at the risk of death or grievous hurt and pulls out a knife to save himself in this situation. Yes, this aggressor or this offender who started off as an offender might have the right to private defense. Why am I saying so? There is a hint in the question itself. The use of this word hints that the examiner is trying to point out an excessive use of harm or harshness by the person who was witnessing the offense by X, right? So Y has used too much harm, excessive harm. So we have discussed this where there is an exceeding of the right of private defense. Now, when you are exceeding the right of private defense, this discussion has previously also happened that in the offense of murder, there is also an exception which protects such individuals, and it says that where an individual exceeds his right to private defense, they are protected, right? So why could be protected under this particular section where he is exceed, but at the exceeded his right. At the same time, X also, even though he is an offender, even though he has perpetrated the crime, if there is a situation where he feels that he is going to lose his life, that the harm which is being done to him is to such an extent that he will lose his life, then in this scenario, he too still continues to have a right to protect himself. These sections that we've just read are equally applicable to him also, where disproportionate harm is being used against him, and where that act of defense of Y has now become an act of offense for X, and he is trying to protect and defend himself from this excessive harm that he is going to do. As we have previously also discussed, that this continues to be a matter which is based on the facts and circumstances of each case. Whether an aggressor is getting the right of private defense of based on the fact that too much excessive rights have been used by the opposite party is a matter of fact, right? In this case, the way it has been phrased, one might feel that there was an intention to try to show that even an aggressor can have, in some situations, a right of private defense. Even here, you see the tonality is such that they are trying to show that even a person who is come to commit theft, if he is seeing harm, may have, but how much harm is being used? Is it disproportionate harm? The extent of harm caused and his retaliation, is that proportionate? Are all questions which come into picture to establish if an aggressor has a right of private defense. So we quickly just have a look at a recap of what we have done through. We have come to part 2 of private defense. We started with now those sections where right of private defense even extends to the causing of death. In the case of private defense of body, we listed out the kind of offenses that are there, right? Rape, unnatural lust, kidnapping, abduction, wrongful confinement, administering acid. We also discussed that assault is so important to understand as a term which has been used here, right? Then we had a discussion on some key factors that are still continued to be involved, that it is still subject to the restrictions of private defense, that it should be done by an individual who is free from fault, he is defending himself, right? We also looked into the debate on unnatural lust, which is still there under the BNS. We then went on to a discussion on, does a husband get punished, or can a husband abduct his wife, and is a right of private defense available against a husband? And we therefore discussed this case, where we found out that it does exist. We also during this discussion understood that while abduction is independently mentioned here, it is in connection with an assault, right? And therefore can be dealt with under this particular section. We moved on to just a short discussion that injuries on an accused must be looked into by the prosecution, and if they are not looked into, it can show that they are trying to suppress something which could be in favor of the accused. Maybe the accused could have been using rights of private defense which the prosecution has not linked into. That differs from case to case and can affect those cases. It was just a short discussion on that. We then moved on to the right of private defense when it extends to harm other than death. So we discussed that in the previous section, you can cause death, but in this section, all other harm that can be caused to you, you cannot cause death. You can cause any other harm, but you cannot cause death. We discussed commencement and continuance of the right of private defense. We discussed how an attempt or a threat which causes apprehension of danger, as long as it is there, your right to private defense continues. We discussed the Jaydev case where we saw that two individuals are killed long after the threat is over. The court does not give them the protection of private defense. The court says that you caused that harm long after the apprehension of danger was over, so you will not be getting the protection of the right of private defense. We then moved on to the right of private defense when it in context of property can even extend to death. We saw the different sections wherein it can extend to death. I also tried to highlight that it includes this tonality where the offenses are such where there is a threat to life also, and therefore you can cause death. Of course, not in all offenses, but some of them you see that nature, right? Then we move on to section 42, which highlights that in such offenses you cannot cause death. You can cause any other harm but death. We then moved on to the commencement and continuance, where we had an in-depth discussion of how, where a person has effected his retreat while committing theft, you are not expected to pursue that individual. And if you pursue and you cause harm, then it is said that you have you have your right of private defense is ended and it has gone beyond that part, right? So understanding the concept of effect of retreat, understanding that your right to private defense in robbery continues as long as you are under a fear of instant death, hurt, right? So again, we see that threat to life becomes a part. Criminal trespass, mischief, as long as it exists, your right exists. Housebreaking, as long as the house trespass exists, the right exists. We again had a discussion as sometimes aggressor may be entitled to the right of private defense, but what are those scenarios where proportionality comes into picture, right? And where it is exceeded, and can the questions themselves highlight and hint at times as where the defense is available to an aggressor, right? With this, I feel that we have had as far as possible a discussion. Lastly, we had also discussed that sometimes even at the risk of harming innocent people, right of private defense can continue. We had a short discussion that there is a right, there is an exception under the offense of murder where people who exceed the right of private defense are given a concession, right? But then it has to be proved that there was private defense and that right of private defense was exceeded. And in the previous lecture we had discussions on how it cannot be weighed in golden scales as to how much force must be used. So all of those factors come into picture if we want to realize that, does the exception come into picture, or the exception is not available also to the individual, and will be punished independent of the exception available under section 300. So all these debates will be dealt with in depth, with further depth, in our classes. I hope that I was able to give you a slight overview on what the private defense concept is all about, and in both of these lectures, as much of clarity I could provide on important facets of this right, I tried to highlight. So thank you so much for joining this lecture. In case you have comments, queries, I'll be more than happy to address them. Please post them in the chat box or in the comment section. Thank you.